Hello everyone. Today I'm going to be talking about the H-1B final rule that was put into effect January 17, 2025. So if you're registering in this year's lottery, this video is for you. As you guys may have already been aware, DHS published the final rule that codified a lot of the changes that happened in the past few years. So I know a lot of practitioners, including myself, were really happy with some of the things that have been codified in this new final rule regarding H-1B and also affecting the F-1 program. So let's go over some of the main tenets. First, we know that this new final rule goes over the definition of specialty occupation. So H-1B visa is a specialty occupation visa, which means your body of knowledge, so the major that you studied in college or in your master's program or even PhD program, has to be related to your occupation. So we've had a string of RFEs and a lot of denials where USCIS seemingly had a narrow interpretation of when is a degree normally required for the position. So in this final rule, it clarifies that a degree in a specialty occupation doesn't always have to be required, but that normally can mean most of the time, right? It doesn't have to be always. So that's a good distinction, one that we've been pushing for in a lot of our motion to reopens and in our appeals. Another thing that it confirms is that in this ever-changing landscape of new degrees and the complex job market, especially with evolving technologies, there may be positions where there are multiple disciplines of like a crossover, so combination of occupation, but also multiple disciplinary bodies of studies that might be applied to a certain work or a certain job. Let's give an example. A UX designer could have a degree in computer science, could have a degree in design, could have a degree in a myriad of disciplines. So USCIS can't say, well, this position is not a specialty occupation because you can't determine that there's only one. You could say now there's a multiple. You just have to prove how that degree is directly related. So the key word here, or the key phrase, is directly related. How is it directly related to the job position? So that's a big clarification, and that's definitely going to affect all of our H-1B processing starting from this year. It just helps solidify what we've been arguing, especially here at Tsang and Associates, but it's good to have it in law. Another update in the rule is that there are going to be more rigorous site visits. So I think starting from this year, H-1B employers can expect to have more visits. We don't know exactly what that's going to look like, but we anticipate that there are going to be visits unannounced. So it's a really important time, and it's really critical to make sure that right now all of your public access files are up to date and are in compliance with the law. So that's my first advice. Make sure all your I-9 forms are also up to date. Even if it's not just for H-1B, I would just update all the I-9 forms for all of your employees because you never know when you're going to get an I-9 audit as well. Another update is that the rule codified a deference policy. So this is typically what we're used to, right? We know that when there's a extension without any material change, USCIS normally gives deference to the previous approval. So if they approve an L1 or if they approved an H-1B in the past, if you're filing for an extension without any material change, same employer, same job duties, right, no big changes, then when you're filing for the extension, it should normally get approved. Now, during the Trump's first administration, that deference policy was repealed to the uproar of a lot of people, and it was restored under the Biden administration, but now under the Federal Register, it's codified under the final rule, so it's not something that can be repealed, at least not easily. But even though it's really great news, just keep in mind that this deference is not a blanket approval for all extensions. If there's any material change, and I've seen cases where USCIS denied it for a material change, even if there was actually no change in the job duties, no change in the employer, no change in the job duties, location, everything was the same. USCIS could still say, well, we see that there is a material change, and cite, well, I don't see how this degree is actually related to the specialty occupation, therefore it's not a specialty occupation, and deny the H-1B. So just be on the lookout. There might be ways that USCIS can get around this deference rule. So if you're filing an extension this year, if you're filing change of status, make sure you consult with an immigration professional. Know that if you get an RFE, you have to make sure that you overcome and meet all the requirements and all the elements of the the petition that you're seeking. Something else that was also really good news for us is that now entrepreneurs, beneficiary owners of companies can also apply for H-1B. This is great, especially if you're a majority owner, you own a company, you run a business, and you want to sponsor yourself for the H-1B. Now it's possible. Because it is a new rule, we don't have a lot of guidance. We know there's some key rules that we still need to comply with or that we still need to follow for an H-1B. One is you still need to show that you're going to be working in a specialty occupation. Just because you're an entrepreneur doesn't mean that you can spend all your time running the business. You still need to have a degree that's related to a specialty occupation. If you have a marketing degree, then yes, you're going to be doing some non-specialty occupation job duties, such as accounting, right, finance, and there might be some other HR, right, whatever you need to do to get the business off the ground. But the majority of your time is going to be doing marketing. So you still need to show that nexus between your degree and your occupation, but this does allow for you to work on other things. Another thing is that you need to show that the company has ability to pay the prevailing wage. So that requirement has not been waived. So this is especially hard for startups. It's not entirely clear exactly how USCIS is going to enforce it. If it's a brand new business, you don't have any tax returns. I imagine taking, clues from L1A new office or E2 new office, I would recommend submitting a really detailed business plan with financial projections to explain how your business is going to be able to afford your prevailing wage. It doesn't help to have, initial capital investment, to have that money in the bank account to say, see, we have some cash available on hand to pay my wage as well. And another thing to note is that the final rule makes it clear that the initial period is only going to be valid for 18 months. And then when you file an extension, it's going to be valid for 18 months. And then after that, you will get the full 3-year extension. So it's still total 6 years, but that initial 3-year period is going to be broken in 2. And I imagine it's because USCIS wants to make sure this H-1B visa category is not being abused and that they want to make sure that the business is doing well enough to support the beneficiaries' H-1B specialty occupation and also that it has the ability to pay the wage. If you have any more questions about the entrepreneur, we're going to be doing a video, so you can check that out in our playlist. Another good news that was codified in the final rule is that the cap gap has now been extended from October 1st to April 1st. So historically, especially since the new lottery system that's now randomized and electronic a couple years ago, we've noticed that processing times can be delayed so that your H-1B might not be approved by October 1st, especially if you're selected in the second or third lottery. You might not even submit your case until past October 1st. There are a string of lawsuits because USCIS denied cases for not having the October 1st start date, even if they filed the case after October 1st, which doesn't make any sense. The courts agreed with us, so now this final rule makes it clear that we can put a start date later than October 1st so that it aligns more with the actual intended start date. So that's a good flexibility and means that USCIS is listening to us. So some things that are not really new updates but are also included in the final rule is that the lottery system is going to be beneficiary centric. This was something that was announced last year, which means that when they do the randomized lottery process, even if you have multiple entries from multiple employers sponsoring you, each beneficiary will only get one ticket or one shot at the lottery. So in the sense that kind of evens the playing field and also reduces the risk of any fraud. Another thing is that you must have a valid passport or travel document to apply for or register for the H-1B. So that's something to keep in mind. That has not changed and that will continue. Something new that's happening this year is also that the H-1B registration fee went from $10 to $215. And if you work for a third-party site, this applies to employees who are working for an agency that sort of sends out contractors to like different work sites throughout the US, or you may work like, if you're a management consultant, then you might work in one company for a while and then you might move to the next. This is something that was heavily litigated in the past couple of years as well. We just have to make sure that there's a clear employer-employee relationship. So your work is being controlled by your employer, the petitioner, not by the client or the site. So that hasn't changed. Make sure you provide ample evidence to show that. Okay, that's it. I hope you found this helpful. A lot of these rules, I think it really does help streamline some of the H-1B processes. It does confirm some of the things that we've been doing already. It gives a sense of security that some of the rules are now actually a final rule. It's in policy, so it's not something that's going to be waived or repealed or rescinded. So Hopefully that gives us more confidence. We know it's going to be a tough H-1B season. So good luck to everyone who's applying for the lottery next month in March. And I wish you all luck and hope you get selected. And we hope to hear from all of you who get selected, and good luck on your petition.